Good afternoon, everybody. It's a little afternoon. I'm sure there's going to be quite a few that are going to be jumping on with us as we kind of progress, but we'll go ahead and get started today. That way we don't take up too much time of your Friday afternoon. So thank you for joining us. I'm Jacqueline Jones-Doyle with the Tarrant County AgriLife Extension Office, and with us today is, mine just went blank, Jason Johnson, who's one of our specialists that has agreed to present for us today. Little housekeeping, if we would, make sure everybody keeps their microphones muted. That just helps with background, as well as keeping your cameras off. That helps with bandwidth. Also, anytime during the presentation, if you've got any questions, please feel free to place them in the chat box and I will relay them on to Jason. With that being said, Jason, I will turn it over to you and we will get started today.
Okay, thank you very much. Let's see here. Let's show beginning. All right. So the first slide up.
Yes, you're good.
Okay. So I'm happy to be here today. I'd much rather do these things in person, but I know that schedules don't permit that all the time. As Jacqueline already said, I'm going to have you submit any questions in the chat box that I'm not monitoring and have her stop me at any point in time to address those, because I do want to encourage you to ask questions if you have them and stop me at any time. I have sent a copy of the slide set and I think that has been mailed out to you, so you don't have to worry about missing a hyperlink or a resource link along the way. And again, we're going to talk about leasing. We'll talk about landowner liability. And the first thing that I'm required to do is to inform you that this is a presentation for educational purposes only. I'm an ag economist. I'm a fifth generation landowner and rancher. I'm in Jack County in Jacksboro, but I'm not an ag attorney, and I'm not a lawyer, and I'm certainly not your lawyer. So the information that we're going to talk about today is for education purposes. Now, I've given this presentation about 50 times. I've heard lawyers give this presentation about 50 times. So it's one of those things where if you ride along with the herd long enough, you can give somebody else's speech for them. But this topic is important to me personally as a landowner. And so what I'm going to share to you is really an economist and a rancher's perspective of these topics. I think it's important that I give you some of the best resources, though, on this topic that is out there. We have an outstanding ag attorney in Extension named Tiffany Lashman, and the greatest contribution I've made in my 25 years with Extension, I believe, is I was on the search committee that hired her. She's that fantastic. And she's got a lot of the resources, a lot of what we're going to talk about today. She has compiled and aggregated and made available through various places. And I want to share those with you first. The first of those places is at what's called the Texas Agriculture Law Blog. Tiffany's a rancher. She's also a lawyer. And so on this Ag Law Blog, if you go to this website that's cited there, under published materials, this is the screen. This is what it looks like. There's actually some online courses there. But what I'm going to make available and wanted to show you is under the handbooks, there's PDF workshop documents that are free for you to pull up and download. Owning Your Piece of Texas, Key Laws Texas Landowners Ought to Know is a great resource. The Rancher's Ag Leasing Handbook, tremendous resource. If you pull that up, this is what is included. It talks a lot about leases, both from a hunting and a livestock standpoint. But the beauty of this document is there is actually some sample grazing leases, sample hunting leases that you can pull up and look at and use and modify for your own purposes. So I want to get these resources and references out of the way first, just to let you know that we do day-long workshops on these topics that we're going to talk about today in 45 minutes. So we're going to scrape the most important top of the topics off, but realize there's a lot more information out there if you need more clarification or details on any specific issue. And these sample leases are some of the most requested documents that I get funneled through the county agents when they're looking, when some of their clientele are looking for references. This is that Owning Your Piece of Texas Handbook. And again, I put this in here so you would have the websites and the links to access these materials. And the other thing she has that is fantastic is she has podcasts for those of you who are so inclined, 7-8 minute topics and interviews with different experts. And you can see this is 128 through 131. So the topics range from risk management, a drought, to mental health, to ag labor issues, to prescribed burning law, fence law, anything you can imagine. And you can scroll through the directory, then see if there's a topic that interests you and actually listen to kind of a dialogue between experts. So these are fantastic resources that before we get started. And with that, let's go ahead and talk about leases. So what is a lease? And basically, lease is nothing more than an agreement between two people that allows one person to temporarily rent property to somebody else. It grants exclusive rights of possession, and it differs from a license. A license is where you basically allow somebody to come on and maybe do the same thing, but a lease is when somebody is, a little bit more formal. They're paying for that privilege and they're paying for certain rights. So within the terminology of the lease, leaseor is the property owner or the landlord. Leasee would be the renter or the tenant. And we'll use these same terms whether we're talking about a grazing lease or a hunting lease. Same thing applies. So basically on a lease, something of value is given in exchange for use of the property or or access to hunting. So the first question that comes up with leasing typically involves whether a contract is valid. Here's our given the same answer to every question, and that depends. Is an oral contract valid? But the bigger issue and the overriding issue is an oral contract a good idea? And that is universally answered no, because there's too darn many things that can be misinterpreted, misconstrued, just misunderstood. And those are where big problems come up, is where one party thought they had the right to do this and the other party did not. Also, those oral agreements are difficult to prove. They're difficult to enforce. And what happens if you have an oral agreement and one of the parties dies or is incapacitated? Throws a whole nother curveball of uncertainty. So we recognize that oral contracts exist and oral agreements exist, and they always will, but you can understand from a lawyer's perspective, the much preferred route would be a written one. So how do courts interpret contracts? Well, again, the lawyer's answer to that is it depends. If the issue is unambiguous and the contract spells something out, then they really don't have to consider any other testimony or evidence. It's black and white, and that makes things easy. If the issue is ambiguous, meaning that the contract didn't address a particular issue, and that issue comes up, then they have to consider the other testimony or evidence. So the lesson here is, you have a written contract, try to put as much as you can in terms of what is allowed, what isn't allowed, what circumstances might arise, and what the consequences of those might be. The more of that that's in writing, then the less room for interpretation and misunderstanding there is. So another issue or topic that is really important to think about when we talk about leases of any type is the statute of frauds. Statute of frauds says that the following contracts must be in writing: sale of real estate, the lease of real estate lasting 1 year or more. So someone says they have an oral lease for 2 years, that's a violation of the statute of frauds. Leases of real estate lasting 1 year or more must be in writing to be valid. Agreements not performed within a year, in other words, expanding over a year. Any loan agreements for $50,000 or more. Any agreement to pay commission on royalties or mineral interests, and sell of goods or services for more than $500. All of these things fit into the statute of frauds. And so the takeaway there is, if you have an oral lease, it's valid as long as it's for 364 days or less. If it extends 1 year or more, then technically that lease needs to be in writing. So the easiest way I thought to organize this topic is to go back to my old buddy Dave Letterman's approach, top 10 lists. So with that in mind, I'm going to talk about the top 10 terms and issues to consider when drafting a lease. We'll start with number 10, term. 3 basic lease length provisions. Tenancy at will means there's really an unspecified period of time. The lease is in effect kind of until one of the two parties decide to terminate it. That's a very poor situation. It's too much up in the air. Periodic tenancy continues on a week-to-week, month-to-month basis with no clear termination date fixed. That's not real good either, because a good agreement has specific start dates and end times. And that's what that tenancy for term of years is. It specifies the length of term. So from a lawyer's perspective, and what Tiffany put together, she just put some samples of some good verbiage that it kind of addresses these topics. And so you'll see there in that verbiage, the term of lease shall be X number of months commencing on X date, continue in effect from year to year thereafter, unless written notice of termination is given at least X days prior to expiration. That's a very straightforward verbiage that allows you to kind of have an ongoing or a rolling lease, but it tells you how long it lasts and when, what's necessary for a notice of termination. Even simpler is the term of this lease shall be X years, commencing on this date and ending on that date. Straightforward. But what the purpose of these sample illustrations do is they eliminate that open-ended term, which gets a lot of folks into hot water. Next, payment of rent. How will rent be calculated? Like a grazing lease, is it per head or per acre or per animal unit? Typically on a hunting lease, it's for a certain amount of property, a certain number of acres. When and how is the rent due? It's not really a good management practice as a landowner to accept rent at the end of the term. Sometimes you can do that on a cropping lease type thing, but for a hunting lease, I'm going to be paid before opening day. That's for sure. If I'm leasing that property for hunting, and then what interest or penalties are there for late payment? So you can see here again, there's some sample language that Tiffany put together. Tenant agrees to pay X dollars per acre or per head for use of the property described in paragraph 1. Total rent of X dollars shall be paid on or before the first day of each month. And if rent's not paid, here's the penalty. Very straightforward straightforward verbiage that addresses that issue. Description of the lease. What is being leased? Recognize that if there's not some listed reservations, then limitations do not exist. So if you're leasing a property and what can the lessee do or not do? Are there any areas of the property that are excluded? How will property be accessed? You know, which entry points or roads does the lessee get to use? On a grazing situation, certainly want to include some limitation on stocking rate for livestock, basically to maintain the productivity of your pasture and the integrity of that. Without these limitations put in place, you know, the tendency or the likely outcome is abuse of the property. It's important when you talk about description of the lease, to me, to include a map, you know, to be able to pinpoint certain areas that this is where they go in. This is the perimeter and the description of the property that's being leased. Here's the stocking rate, or here's the, you know, the things on hunting that either are allowed or are not allowed within the lease. So they say a picture's worth 1,000 words when you're describing what's being leased. That's why I like to have a map in there. Transferability. Can the lessee sublease or assign the property? Is consent from the landowner required? If you don't put that they can't do it, and you don't put that they have to do it with the landowner's consent, then that's open for interpretation. Can the leaseor lease other portions or rights to the property to other people? And what happens if the property gets sold? These are all kind of contingencies that some simple verbiage can prevent from muddying the waters here. So the sample there says that the leaseor should sell or transfer title to the property. Then that action is done subject to the provisions of the lease, meaning the lease goes with it, and hopefully that lease has a beginning and an ending term. But if the transfer takes place midstream here, the lessor would know that their lease was still in effect, at least until expiration. Leasing may not assign or permit third parties to occupy any portion of the lease during the term of the lease without written consent of the leaseor. As a landowner, I'm definitely going to have that verbiage in any kind of a lease contract, because to me, a lease, whether it's oil, whether it's hunting, whether it's crop, whether it's grazing, a lease is kind of like an arranged marriage, and you're agreeing for a certain period of time to work together. And I don't want to be told who I'm getting married to without knowing them first. And that's what happens when someone can assign or transfer their rights without consent. Next one is right of inspection, and unless those rights are reserved in the lease, the landowner gives up their right to enter and inspect the property. And that's a real hard pill to swallow as a landowner. So I'm always going to have the right to inspect. I'm not there to go snoop. I'm not there to go see if they're doing anything that I don't approve of. But I have a hard time turning over the keys to a pasture and saying that I'm not, as the landowner, I'm not going to go in there if I need to, or so, but without reserving that right, I'm giving that up if I lease my property to someone else. So again, sample verbiage there. The landlord, as well as agents, employees, reserves the right to enter the property at any reasonable time for those purposes that are spelled out there. And again, none of this is to interfere with the tenant carrying out their regular operations. Just another point that sometimes causes a lot of heartburn. If the landowner is constantly coming in there and snooping around and didn't reserve the right or to do that from an inspection standpoint. Liability and indemnification. Liability. You want to state that neither party is liable for the actions of or damages caused by the other party or his agents or employees. The reason why this is a really big deal is because by having a written contract, the inclination would be for an outside party to consider that essentially a partnership, because each party stands to benefit from the other. And that's really, from a landowner's perspective, that's not the relationship you want. You do not want to be held responsible for bad decisions or bad actions made by another party. So you want to specifically, at arm's length, say this is not a partnership, and I'm not assuming responsibility for the actions of the landowner or the tenant, whichever one that I'm not. So there's sample verbiage there. And then indemnification, what that means is if somebody does some damage, then you will make the other party whole. Agreement that if one party is sued due to action or an action of the other, the responsible party will defend and pay any judgments. So basically, you have to defend and pay judgments for your own actions, even if your counterparty, being the tenant or basically being the landowner, gets sued. So let's say somebody has a hunting lease and their hunters go out and they have a campfire and they get drunk and they cause the campfire gets away and causes damage to a neighboring property. Well, the chances are the neighboring property is going to go after the landowner. And so this indemnification clause is put in basically to protect you from negligent or bad acts by people that you would lease the property to. Next issue is maintenance of fixed assets. Who's going to maintain houses, barns, specifically fences, watering facilities, wells, and pumps? And I've seen it both ways. It just needs to be spelled out in the lease. And if the landowner's, like for grazing, if the landowner is leasing out the property and responsible for the fences and fence maintenance and the watering, then the lease has to be at a higher price than if a landowner's leasing that grazing rights and the tenant is taking responsibility for those. Typically, what the landowner is going to or want the tenant to maintain the fences because it's their livestock. But again, it needs to be spelled out who's going to be responsible for those assets. And again, there's sample verbiage there. The main thing is just agree ahead of time. I'm going to take care of that. You're going to take care of the other, and we come to some agreement. Premises liability, and this is going to be the focus of what we talk about in the second half here pretty quick. And basically, what is important to know here is that the landowner has a different common law duty or responsibility to a counterparty based on how that counterparty is classified. So let's just take the trespasser. As a landowner, I have a duty to someone who's trespassing on my land. And that duty is I can't intentionally harm them. So I know the signs that say, trespassers will be shot are kind of funny, and I can certainly understand that as a landowner, but legally and responsibly, you can't do that. But beyond intentionally harming a trespasser, you don't owe them any other responsibility. so that if a trespasser's on your property and they fall and they break their leg, they can sue you, but it's not your, it's, it's not your responsibility to warn a trespasser that there's some dangerous conditions out there. You don't owe them that. The only thing you owe them is not to intentionally harm or hurt or maim or, do the things that you'd probably want to do to a trespasser. Second one is licensee. A licensee is someone who basically comes out to your property. They're not paying. They're kind of an invited guest. Basically, they're a relative, an in-law, someone that's out there to, perform some kind of service. You must protect against known dangerous conditions only. No duty to inspect. So if they come out, if there's a known dangerous condition, you need to take care of it as a landowner, but you don't have to go out there looking for those things. It's only the ones that you know of. It's a very low threshold level of obligation because the other party is out there for their own benefit and they're not paying you. You're not benefiting necessarily from their attendance on your property. The third level of person is an invitee. And an invitee is somebody who's basically a guest that is a paying guest. Someone who is paying for the right to access your property or your resources, a leasee, someone who's providing money and a benefit to you in exchange for something else. If they're providing funds and they're paying, then you owe them a higher level of obligation than you certainly do a trespasser or someone who's there for free. The common law duty that you are required is you must give adequate and timely notice of dangerous conditions on the property that you know about or that any reasonable inspection would uncover. So if you have paying guests via a grazing lease or a hunting lease or some other agritourism type of activity, then as a landowner, you need to at least do some cursory level of inspection to make sure that I can identify any dangerous conditions that are there and then inform those paying guests of those. Then the last common law duty and a type of classification is an individual called the attractive nuisance. And this is basically children, minors who are not able to realistically evaluate the risks and perils associated with different things. Extra protection for children. It's an enhanced duty for landowners. If you know that children frequent the place and, the activity or the potential peril poses a risk. Typical example here would be old dipping vats for cattle that might fill up and pose a drowning risk, or an abandoned windmill tower. If you have any reason to suspect that children may be on the premises with or without your knowledge, and you've got those kinds of things, and something bad happens to a child, whether you knew they were there or whether they had permission to be there or not, they're going to look and say, how much would it have cost you if you knew children were there and or had evidence that children had been on the premises? How much would it have cost you to remediate that peril, to pull down that tower or to fill in that pit? And how much would that have cost relative to the probability that a child might get hurt? Nobody wants the court to be asking these questions. So as a landowner, you got to look at some of the things through a different set of eyes on your property and recognize, do I have things out there that children might be drawn to? And what's the worst possible scenario that could happen? If you have to start defining those things, then I would suggest look at ways to remove that peril, fill it in, tear it down, whatever you needed to do, because courts are going to protect children, And unfortunately, accidents happen through no fault of anybody's, just from the nature of antiquated or abandoned agricultural or other business enterprises. But this is really important. This is a common law duty topic, and your common law duty escalates as the person who's visiting your place is invited and pays money, or is a child unable to realistically weigh the risks and perils. Legal considerations to be included in a lease. Choice of law provision. If you're Texan and in Texas, you want Texas laws to prevail. That needs to be in the lease. Forum clause, where if there's any issues that need to be decided, what's the home court? And everybody, landowners will want to make this their home court, but specifically if they do things like hunting leases and have people from metropolitan areas or near or far come to take part in those activities. Something happens and I'm a landowner in Jack County, I do not want to go to Harris County to have a case heard. So within the lease, there's a forum clause that says if there's any activity, any action, any legal issues or remedies sought, those will be sought in the courts of Jack County, Texas. And then there's dispute resolution clause samples, basically just saying, the opportunity to have things go to arbitration and selection of independent arbitration parties. State that the lease does not create a partnership. Again, any lease, grazing or hunting, you do not want to be considered a partner with the other party in case the other party makes a really bad decision or causes some financial damage. You want to make sure that it's explicitly said that you're not a partnership. Attorney fee provision, and this is, this is put in there to prevent frivolous lawsuits, saying basically if the party loses, they're going to pay reasonable attorney's fees for the party that they sued. And then confidentiality clauses, all these terms related to payment shall be considered confidential and not disclosed to third parties. And that's basically just kind of a privacy notice. Last one of the top 10 terms is professional review. And of course, since this kind of philosophy and topics were defined by a lawyer, you can imagine that the number one thing on their list was, any lease agreement, get it in writing and have an attorney review it. And that's really good advice. Especially if you have a large number of assets, and most people that own land are considered to be wealthy and rich, even if they're very cash poor, it doesn't matter. Have it in writing, have an attorney look over the thing. If you put together some of these things from the sample leases, sample documents that I've given you reference to, modified it to basically put in the stipulations that you want and write them in plain English, what's allowed, what isn't, and then take that document to a lawyer to review, I suspect it'd be a very reasonable legal fee. And they may have verbiage that they want to pull out of some dummy templates and replace, but at least they'll know what you're intending to allow and not allow, and they will be able to troubleshoot or look for things that are not included that need to be, or that need to be rephrased. So you can always go the legal Zoom route and go to Staples and get a template, but at some point in time, you got to weigh the risk and reward of having a properly executed and worded legal document. So last things I want to hit on, and some of these are specific because grazing and hunting were both the topics. From a grazing perspective, the lease term and duration and even the way leases are calculated from a grazing standpoint will largely influence how the land is treated. If you look at this picture, and I've seen this 100 times when I drive down the highway and look from one fence to the other, my guess is that the pasture to the left was drawn up on a dollar per animal unit basis. The grazing lease was. And the grazing lease to the right of the fence was $1 per acre. The reason is the $1 per acre, if that's the baseline for which rent is paid, then the incentive is to stack as many lives, use it as a hotel, stack as many cows or horses or goats on that property as you can. If it's $1 per animal unit, then the incentive is to graze it more moderately, because you're only really interested in grazing to the point where a certain number of livestock are putting on weight or maturing and you're not having to supplement them. The same goes with the term. If I have a 1-year lease, then I'm on the right-hand side of this screen, because the incentive is to the leasee is to take every blade of grass off that pasture, because the lease is up at the end of the year and next year will be somebody else's problem. If, however, you have a multi-year lease, then you're going to have a situation more like the left-hand side, where the grazer is going to do the old take half, leave half, and allow for regrowth, because they got to come back next year and they want forage to be available. So just recognize that the lease duration and the way the lease is structured in terms of payment, both will have very real impacts on how the land is treated. From a grazing lease perspective and pointers, number one, set a stocking rate. I like to think about putting enclosures, and it's basically take a hog panel, cut it and build a box, a four-sided box out of that hog panel, and then stake it in the ground in the pasture. And then you can evaluate the height of the forage outside of the box where grazing is permitted, and the height of the forage inside of that hog panel where there is no grazing, and you can kind of get a feel for, when the height of the forage outside the box gets to a certain level, cattle need to be pulled off. That's a very, very visual and flexible way to incorporate stocking rate. The other one is just to say this, this grazing this pasture will permit or allow X number of head for X number of days, or a certain period of time, grazing from March 1 through the end of September or October, and then cattle need to be pulled off however you want. But a stocking rate is a must on a good grazing lease. Term of lease and cancellation: how long does it last? When does it terminate? What can be done on the property? What type of animals you want to allow? Maintenance of fixed assets. Again, the fencing and the water become a really big issue, so know who's supposed to take care of that. And then last, mineral estates and any conservation programs that exist and their limitations. Those are extraneous issues that the leasee needs to be made aware of. The leaseor needs to describe those. So real quick, on the mineral estate, recognize, if there is a mineral lease in place, identify it, or if there's one being negotiated. The mineral estate, oil and gas exploration, is the dominant estate in Texas. So even if someone has a grazing lease, even if I own the surface of the property, I'm the landowner and own the surface. If someone else owns the minerals, they have the right to lease that. And the oil and gas company has the right to come onto my property that I own the surface rights to, or the property that I'm leasing and paying money for. That oil and gas company has the right to come in there and use as much land as they need to do their work, build roads wherever they want, drill wherever they want, put up, pump jacks, oil storage to basically disrupt anything they want. That's part of the mineral estate, and that's the dominant one. So if the landowner and the leaseor does not have the minerals, that's a risk that both parties are facing. You have to recognize that it's a really big issue. I would not lease property from someone else, even hunting, without knowing who can, does the person leasing me the surface rights, do they also own the mineral rights? And what can I expect to see there? Have provisions in there that allows the tenant to cancel the lease and get a refund if mineral production starts up and disrupts their production. All the time, I get asked to provide estimates of damage caused by oil and gas exploration. Damage to crops, damage to livestock grazing, damage to fences, and so that they can settle up on these types of inherent issues that pop up when oil and gas exploration takes place or starts to become prevalent on a property. Moving to hunting leases, the pointers there. Man, there's so many problems that can point up that pop up when someone not familiar with general ag production or rural atmospheres comes from urban atmospheres, urban environments, and opens gates and goes through gates and doesn't shut gates and shoots everything that moves. This is a joke, but in Jack County, this is reality. We have, as livestock producers, if we have hunters coming on, we typically try to round them up and get them as far away as possible from the hunting activity, just because there's too darn many stupid mistakes that can take place. On a hunting lease, require everyone to sign lease and sign waivers. Limit on hunting methods. Are they bow hunters? Are they going to come in here with high-powered assault rifles and shoot pigs? Or specify hunting periods and species. What are you leasing the right to hunt? In what time period? Require the leasee to follow all state and federal laws. And again, the map is a very valuable tool when communicating where are the perimeters for the hunting to take place, what entry and exit gates and roads may be used, and those considerations. So these are kind of the top 5 issues that are pertinent to hunting leases. The other question that I get is basically, what are the going rates on different types of leases, both hunting and grazing? But we know those vary depending on the state, based on the size or the acreage of the plot. It really ticks me off to look in the paper and see someone advertising 10 acres in a urban fringe area, 10 acres and listed as an ideal hunting property for deer, turkey, hogs, quail. I'm sorry, but 10 acres shouldn't be allowed to be hunted like that, because anything you shoot is going to be close enough to be going over on the neighbor's property, but it happens. What are the rates? Is it year round or seasonal? Man, if I'm a landowner, I will never grant a year round hunting lease, because what you're basically doing then is you're basically saying, hey, come lease your own personal state park. Come in a state park that allows you to shoot the animals. You turn your hunting lease into a glorified campground, and that's not the intent either from most landowners. Does the lease provide housing, water, electricity? All these things influence the prices. So how much should you charge? You can talk to county extension agents. You can talk to other landowners. Some may not want to share that information. So I want to make sure everyone is aware of this resource. It's put together by the Texas chapter of the American Society of Farm Managers and Rural Appraisers. And every year they put out a handbook, an annual book called Land Trends, and the most recent one is 2021. In December of the year, they get together, gather the information, and then in the spring of 2022 is when the 2021 document came out. So it's fresh. And next year in the spring of 2023, the Land Trend 2022 book will come out. What that book does is it takes clusters of counties in different regions of the state, and it reports the range of cash rental rates for different types of land. And you can assume that the improved pasture rental rates are being used as grazing. And the same goes for the native pasture. And it also, for many of these clusters of counties, will report a hunting lease range as well. This is updated every year. It's objective information, and I realize there's a big range between, $10 an acre and $25 an acre for native pasture for grazing. And that range is, again, tract size, proximity, infrastructure. But at least it gives you a ballpark estimate of the going rate for cash rental range. And it also, and just as an example, this is what the data looks like. They clustered North Texas in 10 counties as a cluster. And they basically reported the cash sales price for different categories of land. And again, notice the range there. It's pretty high based on tract size and proximity. But then they give a cash rental range. And you'll notice as these hardwood tracts reflect only fair timber quality, and income is from hunting leases. And then they give a different cluster, Northeast Texas, with another list of counties and their prices. Same example, same handbook, different cluster, and this would be south of the Metroplex on that I-35 corridor, and just to the west of that. And I put this one up here I want to illustrate something to you on this category, on this cluster of counties here. Look at the cash value, the price, sales price value ranges between native pasture that's open, $2,750 to $7,000 per acre. And then that below it, native pasture wooded, the sales price was $3,700 to $11,000 per acre. We have a lot of landowners out there that go out and clear a lot of brush. What this data tells you is that that's fine if that's what you want to use the land for. But if you ever want to sell that land, the market would much prefer that land to be wooded. You're decreasing the value of your property, maybe $4,000 an acre, by paying to have the brush removed. And what that basically tells us is what we already know. Land is priced for its recreational value, not its ag productivity value. But again, this document is very useful because it comes out every year and basically reports rates, cash rental rates, ranges for different clusters of counties. The last document, that resource I wanted to show you, this is kind of an older one, but Judon Fambro, an attorney at the Real Estate Center, fantastic speaker. He knows his stuff. He put together what's called the Texas Deer Lease publication, and it goes through a lot of these specific rules on, you see the list there: traffic, hunting blinds, gates, keys, inspections, camp safety, landowner liability, and it will reiterate a lot of what we talk about in the second section. But again, this resource puts a lot of verb and explanation behind the information that's important to those that are looking at hunting leases. So that is the end of the first part of the program, which is just general lease issues related to grazing and hunting. And if anybody's still awake, I will ask Jacqueline if there's anything in the chat box. Let's see. Chat box.
This time, there's not any questions, Jason.
Okay. Well, and I'll give everybody a second to ask those while I take a swig of water before we move to the to the second part. Okay. Hearing no questions, we're going to go through landowner liability laws and steps to protection. And we'll go through this pretty quick because a lot of it we've already kind of touched on, but I'm going to highlight and illustrate a few statutes that exist that are intended to protect landowners, basically because if these protections did not exist, landowners would never make their land available to other parties. And, you know, the fact is 95, 96% of the state of Texas is privately owned. So unlike a lot of other states that have federal lands and national parks and things in them where everybody can take their hobby to those locations and gain access, Texas is a different beast. And you pretty much have to go through a landowner to gain access to land for certain activities. So let's talk about land. And this is landowner liability is the major deterrent or barrier for a lot of landowners in permitting those activities. So let's talk about those. And I want to start here. If you look at this picture and you look at the slide, I always ask people to tell me what they notice or what's different. And if you look closer, the answer to that question, and this is from an economist, is that the livestock operation on the left-hand side, on both those pictures on the left, is a heck of a lot more profitable than the livestock operation on the right. In other words, a cow standing in the shade of a pump jack tends to have a more profitable operation than a cow standing under the shade of a mesquite tree. From a lawyer's perspective, if something goes wrong and you have a client who was an injured party, guess who they're going to come after? They're going to come after whoever has the deepest pockets. That's just the way they work. And so the reality here is as a landowner, you can be sued for anything. There's nothing that will keep you from being sued if someone wants to sue you. There's a lot of things you can do to make sure that other party doesn't prevail, but you're still at risk of being sued, and that can be a very expensive proposition. You know, even if you win every step along the way at the local level, at the appeals court, as at any level that it goes up, you're racking up defense charges. So the objective here is to make sure you cut that off as quickly as possible and you know, do the things that keep you from being sued or keep you from losing your suit. So basic landowner liability, and we've touched on this. So two types of claims: negligent act and premises liability. For premises liability, negligent act is were you negligent as a landowner? Basically, did you not meet your common law duty? And that premises liability based on the personal trespasser, only shoot them or harm them or hurt them. Licensee, your duty to warn or make safe any dangerous conditions that the landowner knows about but may not be obvious to the other party. And then an invitee, duty to warn or make safe any dangerous conditions known to the landowner or which the landowner would have discovered with any reasonable inspection. That's the paying guest, and that's the highest level of common duty owed to a counterparty. The attractive nuisance I'll skip through this because we already talked about this one. Basically is the common law duty for children drawn to attractive nuisances that are known to exist on the property. And how, did the landowner take steps to reasonably, remove those entities? So trespassing, how do you notify someone that trespassing is not permitted? And, the obvious is post a sign. You'll see purple paint in Texas as a substitute for a no trespassing sign. But basically, these are the different ways that trespassing, notice of that trespassing is prohibited can be conveyed. Notice can be given by oral or written communication from the landowner that someone with authority or someone who has authority to act on the landowner. Well, trespassers usually don't come by and visit. So another way that you can issue a notice that trespassing is prohibited is simply by having a fence. A fence or other enclosure designed to exclude intruders or to contain livestock is essentially the same thing as a no trespassing sign. Sign or signs posted that say no trespassing, those work. Placement of purple paint marks on trees or posts, those are a notice of no trespassing, as well as the visible presence on the property of a crop grown for human consumption that is under cultivation in the process of being harvested or marketed if harvested at the time of entry. In other words, a growing crop is a no trespassing sign. A fence is a no trespassing sign. A sign, purple paint, all of these are no trespassing notifications. Now, on the purple paint, just putting one purple paint on the corner post is not sufficient. There's rules, 8 inches in length, not less than 1 inch wide, not less than 3 feet from the ground or more higher than 5 feet from the ground, and placed in readily visible areas no more than 100 feet apart on forest land or 1,000 feet apart on land that's not forested. So basically, there's the restrictions on purple paint as a no trespassing sign. And if you put that up and then a trespasser comes through and gets hurt, as long as you weren't the one pulling the trigger or setting a trap out there for them to get their foot caught in, you're going to have a very low level of obligation to those individuals. So post appropriate signage. So 5 steps to liability protection. Number 1, liability insurance. Number 2, meet your common law duty. In other words, identify any dangerous conditions on the land and either warn those guests or invitees or make that dangerous condition go away by remediating it. The third way is to obtain a written liability waiver from anyone on the property. And the question is the liability waivers worth the paper they're written on? The lawyer will say, well, it depends. How, when was the liability waiver obtained and how was it obtained? What is in it? How they, did they, a liability release waiver that I get from my hunter on the night before opening morning is probably not going to be a very defensible item, because the courts would look and say, well, they didn't have a choice. They were coerced into signing that, and they may or may not uphold it. If I obtain that liability waiver a month prior to the opening day of hunting season, that's a different ballgame, and it'll give more credibility. Different business structures afford different levels of protection. And then the last one, and the one we'll hit that's specifically designed to provide some protection to good intentioned landowners, are these liability statutes. And there's different types that we will touch on. So these are the 5 ways that we're going to talk about, kind of best management practices for each one of those. Starting with liability insurance, every landowner needs it, just like you need it on your house in town. Liability insurance is one of the cheaper insurances, quite affordable. But the reason you need it is because it's cheap, and the probability of you ever having to draw on it is low, but the magnitude of the damage that it could do to your financial well-being is so large that you just can't afford to be uninsured. You need to ensure that every activity you have on your property is recognized and covered in that liability policy, which means you almost need to have an insurance agent that's familiar with the common practices that take place on your property. No, and if it's just an in-town property, an insurance agency that specializes in urban and residential works. But if you have a rural property and you have an ag operation, you want an insurance agency that specializes or is at least familiar and comfortable with insuring agricultural and rural citizens and properties. Look at the caps on coverage in the fine print. That's what you want to make sure that you're adequately covered there. And look at umbrella policies. You buy an umbrella, basically takes your existing liability policy and adds an additional layer of dollars of coverage for the same perils very cheaply. It is the cheapest, it's a very cheap way to add $500,000 worth of additional coverage, okay, at a very low rate. The main thing on the liability protection through insurance that I want to point out is, and to me, it's great. This is an equally great value to it, is let's say you have insurance for $1 million and something happens and you get sued. Well, they sue you for $1 million. Well, guess who is on the hook for that? The insurance company. Guess who's going to decide, hey, we want our lawyers to defend this thing because it's our money at risk? The insurance company. And they probably have some very, very, very good lawyers, much better than I could afford individually. So like I said before, anybody can be sued for anything. But and it can be very costly if you're having to pay those defense costs out of your own pocket. But if you have insurance and the right amount of insurance and you're sued, and the insurance company will provide your legal defense and legal defense costs at their expense because it's their money at risk. Man, that is a fantastic perk and benefit and gives me a lot of peace of mind in terms of my landowner liability. So get adequate insurance from an entity that understands your business, your situation, and make sure those liability coverage levels are sufficient. And we'll talk about those here in a minute. Secondly, identify dangerous conditions, meet your common law duty. The picture there at the bottom basically is the graphic illustration of the cliche, the best fertilizer in the field is the farmer's footsteps, knowing what's going on his own property. And that's what we're really talking about. Do an inspection, look for dangerous conditions, make them safe, or at least warn your guests. Meet your common law duty to those trespassers, children, invitees, or licensees. Number 3, obtain the written liability waiver. General rule, Texas will enforce releases if properly drafted and the injured party is an adult. Properly drafted, that's a legal term, and that changes with the courts. So this is one of those things where you want to let an attorney take a look at your liability waiver and then get suggestions from them, not only what that document says, but how you present and obtain that release from the people that are going to be entering your property. I want a liability waiver release secured properly from everybody that goes on my property. So in my hunting lease, when I'm the land that I lease to hunters, in addition to them both signing the lease, I have them both sign liability release waivers, and I get that far in advance of opening day. It's just kind of a best management practice. But let an attorney take a look at that and like I said, not just for what's the content, but to get suggestions from them on, okay, when do I need to put these in front of them? And how do I secure this, in a manner that won't be construed as, we are coercing somebody to sign a piece of paper right before they go through the gate. The liability waiver requirements, there's some express requirements, and here's specific verbiage. Release any and all claims against the landowner, include claims for negligence and gross negligence. I'm not sure whether you can be absolved from gross negligence, but the verbiage is there nonetheless. Signed near the time of the injury, not the day before the injury, but a liability release waiver that I've got that's 10 years old on hunters probably ought to be revisited and signed again. And specifically address the activity that they're there and paying for, so that if they get hurt doing some other activity outside of that, that goes into my favor. We're always kind of building defense mechanisms and documentation and processes that will work in our favor if something happens, and don't hide it in the fine print. So don't have the printed in the same size font as the lease, or in a normal type font. Fourth is consider business entities, and this is not my specialty, other than I do recognize that there are some differences in liability to the owners of a limited liability company versus the liability that exists for sole proprietorships or partnerships or corporations. There's pros and cons, and they go far beyond just the liability protection. They go to reporting requirements and tax reporting requirements. So you want to utilize the one that best provides you the protection you're seeking without layering an additional burden of financial responsibility and costs and expenses. And again, there's a good podcast there that addresses those. Certainly a topic that you might want to visit with your attorney on. And then lastly, and we're going to go into these real quickly so you know the difference, ensure that limited liability statutes apply. There are liability protections afforded through these three specific acts and statutes. And with compliance, meeting those common law duties, and posting the appropriate signage, it does afford landowners some protections that, have evolved over time as accidents and incidents occurred. So let's talk about that Texas recreational use statute first. It's basically to encourage landowners to open their private property to the public for recreational uses. Landowners are only liable for intentional acts or gross negligence if the statutory requirements apply. First off, is it on agricultural land, ag exempt land, land that's growing crops or producing livestock? Agricultural land, is the plaintiff there for recreational purposes? And did it include one of the three listed monetary requirements? First off, ag land, Texas land suitable for production of plants, fruits, grown for human or animal consumption, fibers, floriculture, trees, industrial, personal, or domestic or native farm or ranch animals. Ag land receives more protection than non-ag land. Limited liability applies to social guests on ag land, Attractive nuisance cannot be claimed for anyone over 16, and cap on damages applies to agricultural land. This is a list of those recreational use activities that fit the definition, and you can see hunting, fishing, swimming. It's very broad. Disc golf, walking dogs, radio control flying, and then finally a cleanup, any other activity associated with enjoying nature or the outdoors. So that's a pretty broad list of recreational use activities that fall under this guideline. The key is, what was the plaintiff doing when they were injured? There was a mention of monetary requirements. You're afforded the protection under this statute if you did not charge any fee, or if the total charges collected over the past year are not more than 20 times your ad valorem taxes on any premises you owned in Texas for the previous year. So you can calculate all of the property taxes that you paid on your urban, household, rural properties, add up all of those property taxes that you paid and multiply that dollar amount by 20. And as long as you did not collect more than 20%, more than that dollar amount, as long as you did not collect in fees from guests more than 20 times what you paid in taxes, you were provided protection under the recreational use statutes. If you did, even if you did, collect more than 20 times your total ad valorem tax contributions, you can still get protection if you have adequate liability insurance. And these are the levels. So this is what constitutes adequate. Liability insurance coverage of at least $500,000 per person, $1 million per occurrence of bodily injury or death, and $100,000 for injury to property. For ag land, if something happens and you're sued and you have this insurance, the liability is capped at these amounts. Meaning, if you get sued, this is as much as they can sue you for. And guess who's on the hook for that? The insurance company. So guess who will provide the legal defense? The insurance company. So these are some mighty powerful provisions and benefits and assurances afforded to landowners that allow recreational activities on their land. But you got to meet one of those three. There's an Agritourism Act, which is to me, it's an extension of the recreational use. It's not recreation. Agritourism could be an educational activity or an experiential activity. The crop mazes, the field days, farm tours, petting zoos. Basically, it's just another protection. Encourages economic development by encouraging operators of farm ranches and rural attractions to open them up to the public. The requirements on this one is agritourism entities are not liable. Plaintiffs are there for recreational and educational purpose. Proper signage is used, and there's several exemptions there. But an agritourism activity is any person engaged in a business or providing an agritourism activity, including exotic animals on ag land, without regard to compensation. Activity on ag land is for recreational or educational purposes. It's on ag land, again, defined as land suitable for production of food or fiber or crops. And then recreation uses those same recreational use statute definitions. So here's the signage. You must post and maintain in clearly visible locations on or near the premises in which an agritourism activity is included the following warning sign. And you'll see these if you start paying attention. You'll notice near the entranceway or near where you pay or someplace that's really readily apparent, there will be one or multiple postings of this signage with this verbiage. This is what allows you and affords that land, or this is what affords that provider of land access the coverage underneath the Agritourism Act. There's release language in terms of liability waivers for agritourism must be signed before the activity takes place by the parent participant or their parent, guardian, or managing conservator. The document is separate from any other agreements. It's printed in regular type font, no less than 10 points. And this is the exact verbiage that you need to have in that waiver. Basically just saying the participant is accepting all risk of injury, death, property damage, or loss that may result from participating. But don't summarize it. When a lawyer says this is the verbiage that has to be there, this is the verbiage verbatim, word for word, no substitutions, that needs to be on that waiver. People that are exempt, if the plaintiff or the injured party is an employee, you're not exempted from performing intentional acts of negligence or harm, and you don't want to get into the situation where the courts has to weigh, okay, on 100% basis, how much of this incident do we allocate to the agritourism provider, and how much of this do we allocate to the participant who got injured? You don't want to enter into that because each party is going to try to be finger pointing at the other. So one of the following dangers in which the entity knew or should have known: dangerous conditions not disclosed. Again, meeting your common law duty goes a long way into alleviating some of these facts or some of these potential missteps. And then the last one, Farm and Agro-Animal Liability Act. This one was basically instituted that says people are not liable for damages to participants in a farm animal activity or livestock show if injury results from risk inherent to farm animal activity. When you're dealing with animals, there's an inherent risk there. There just is. And they're subject to numerous exemptions. The farm animal liability states there's a propensity of animals to behave in ways that may result in injury. Unpredictable activities, unpredictable actions from a farm, when dealing with farm animals. Respect to equine activities, certain land conditions and hazards, including surface and subsurface conditions, holes that they might step in and pitch off a rider, collision with other animals. In other words, this is basically saying there's a lot of things that can go wrong when dealing with animals, no matter how tame or their manner, behavior, or, there's just a lot of things that can go wrong. A farm animal professional is anyone engaged for compensation in instructing a participant or renting to a participant an animal, equipment, or tack, or who provides veterinary or farrier services. You must post, if maintain a stable, corral, or arena, you must post the signage where the activity occurs, clearly visible and clearly readable. And there is, again, verbatim, the specific language that you need to post or that you will see posted in any area where animal activities are ongoing and providing compensation. So if it's a livestock show, there's verbiage there specific to that, and basically just telling everyone that there's inherent risk associated with livestock show activities. Exceptions to this is injury caused by faulty equipment or tack provided by the defendant who knew or should have known it was faulty. So there's a low risk if you're providing saddles for horses. If I'm a landowner in a hunting lease and I'm providing the hunting towers or the deer stands, I'm assuming a certain level of risk in saying I'm providing those. So it's the same kind of thing. There's exceptions if the defendant did not make a reasonable effort to determine the ability of a participant to safely engage in the activity. That's why any horse activity, they will always ask the participant, what level are you in terms of riding? Are you experienced? Or is it your first time? They will try to judge your level of familiarity, comfort, and competence before placing you on an animal, so they don't put the kid who's never ridden a horse on the meanest, gnarliest horse they have in the arena. So they have to do some type of assessment of skill and match that if they're providing, pairing them with animals. And you're not exempt if you cause dangerous condition of the land controlled by the defendant without warning signs or verbal warnings. Can't willfully or wantonly disregard the safety of the participant or intentionally cause the injury. Those are no-nos. No sign protects you from that. And that's pretty much the extent of it. So those are the ways to cover your rear end from liability, and hopefully the pairing of the leasing and the liability will answer any questions you have. Again, the resources that I provided to you go into a lot more depth and detail, and I'll let you pick those topics that are the ones that are most important to you, that you want more information on. And again, I appreciate the opportunity to visit with you. I hope you found this useful. And if there are any questions, I'll be happy to take those.
Go ahead. You saw it. Go ahead.
I say, how would you recommend an individual identify a lawyer who is familiar with the legalities that have been discussed today in one's county of interest? The main thing, you want a lawyer that works with landowners, and you want a lawyer that, you want to find a lawyer who's familiar with the activity that you will be providing, so that you get a good lease document drawn up, and you get a good liability waiver drawn up if it's like a hunting thing. There is no substitute to word of mouth. And what I would do is I would contact your county extension agent and say, this is the activities I've got going on. Do you either know any other producers who provide that kind of activity, or do you know lawyers who work with landowners that provide that activity? Another landowner, you can get on the internet and find Texas landowners that are typically providing the same thing that you're going to provide. Heck, call them and say, who did you get to draw up your agreement, and who did you get to draw up your waiver, and ask them for lawyer recommendations. So the answer to that is there's no substitute for word of mouth referrals. And hopefully we, through extension, are able to help you find those individuals that can give you those recommendations.
Can you hear me speaking?
Yes.
I do appreciate that response, especially about the county extension agent. In the word of mouth, I know what you're talking about. I've dealt with lawyers a handful of times in my life. Fortunately, haven't had to have any serious situations addressed. But inevitably, you go to one lawyer and get some advice, you go to another one, and he or she might give you a little bit different advice. That's why I asked about the specifics of a lawyer that's involved with agricultural land or recreational use land. But yeah. So, I didn't know if there might be, a specialization in the lawyer business.
Well, I think the specialization comes from repeated activity. You become an expert by working on the same topics and issues. So while there's not necessarily a designation and a certificate that says I'm a specialist in this area, people in Jack County, by gosh, the lawyers here, if they deal with ranchers, are going to be well versed in hunting leases, just because that's the nature of the beast. There's also, from a hunting perspective, a hunting lease and making sure the verbiage was there. The Texas Wildlife Association, I'm sure has a list of sponsors and attorneys that work with landowners So there's a lot of, specific entity associations that I might look to look for references and recommendations as well.
Very good. A different question. You commented earlier about the use of purple paint, and
Yes.
In the slide you discussed the requirements for applying the purple paint and distinguish between forested land and non-forested land.
Yeah.
So not to get too hung up on detail, but what defines forested land? In other words, some properties are very heavily wooded, some are.
Well, and I think, like you said, you can visually look and say, is this timberland or not? I would default back to my property tax definition, and is it it's going to be defined as ag land, but if it's valued based on timber in certain parts of the state, that's going to show up on that property tax. I would view that as forested land.
Certainly, good point.
So that's what I would use more than anything in terms of kind of a classification. Sometimes common sense prevails in these things, and sometimes it doesn't. So what you want to do is kind of pair common sense with some type of documentation or justification for why you drew that conclusion.
And where did the concept of using purple paint come from? I conclude that it's a color that is obvious out in nature because we don't see it as often, perhaps, and it is bright.
It stands out. But primarily, the obvious answer to that question is that stands apart from what we see. Like you said, 90% of nature, other than a few wild plants, that doesn't show up, but the paint itself was intended to be a notice to people that were illiterate, that could not read the warning signs. That paint would be, a paint would be a distinctive, observable notice to someone who couldn't read no trespassing. And purple would not be a color that would be, likely to be the same color as somebody's entry gate or I've seen green T-posts and I've seen red T-posts and silver ones and black ones. I don't know that I've ever seen purple T-posts. So, it's one of those, it's just a off color from what you see in the backgrounds, but it's basically designed to provide notice to people that are incapable of reading or reading English.
I think I'm a little bit embarrassed at nearly 60 years old and spending a good bit of my time out in East Texas, not having seen that before or heard about it. I saw it, again, a little bit embarrassing here, maybe, on Lone Star Law, they were talking about it. And I was like, well, my goodness, okay, I didn't know that. So,
that's a fantastic show from the perspective of looking to see what all could be misunderstood and miscommunicated, because there's a lot of times when they arrest somebody or pull somebody over and start questioning them, and their immediate response is, well, so and so owns this land and told me I could do this or I could do that, and come to find out they didn't. But if there is ever an illustration of why a written lease as opposed to a verbal lease is needed, watch that show for a couple of episodes and you'll be convinced.
One of those episodes, one of the officers made a comment along the lines of what you're just discussing here, that the landowner, I don't believe I heard it right. I made a note to research it, but something about you had to have a permit to lease your land?
Absolutely. And I'm very much, that makes me mad as a landowner, but in order for me to lease my property to hunters who come from the Metroplex, I have to go down and buy, in my case, the cheapest one is a $75 land leasing permit that allows me to lease my own property for money to someone else. I can lease my property for them to go out and grow crops. I don't have to have that permit. I can lease my property for them to graze livestock. I don't have to have that permit. But in order for me to lease it to someone else to hunt on, I have to have that permit, and it has to, that the leasee needs to have that on in case they're asked for it. And the fine is like $500 if you don't. Again, it's just another revenue raising opportunity for Parks and Wildlife, which I get. I can understand. We got to fund the compliance of these game laws one way or the other, and licenses is one way that it does it. But yeah, landowners, if they lease for hunting, are supposed to get a land leasing permit. In my experience, in confidentially talking to landowners across the state, I'm going to say about 20% of them actually do. And very rarely have they been asked for that document, but sometimes, you get caught. So landowners typically weigh the risks of getting caught and paying the fine against having to pay the $75 every single year or more, and they make their decision accordingly. But yes, that's another law that's on the books related to leasing is for hunting lease, is to have that permit.
Thank you for that clarification. I didn't realize it was just for the hunting lease.
Yes.
Great. Okay. Thank you for that. Seems like I have one more question I was going to ask you, but it's escaping me now. Anyway.
Well, and you can always email me. My email address is there, and I'm happy to respond back to individual questions. And again, I'm not a lawyer, I'm an economist, but I'm a fifth generation landowner. So and worked with extension for 25 years. So chances are I've seen the question before, and if I don't know the answer, I'll direct you to someone who does.
I remember my question now. The question now. I worry about in this day and age, people suing people and whatnot. If somebody has an unfortunate event on property that one owns, and they have adequate liability coverage and an umbrella policy and all that, the individual sues you, the landowner, right?
Yes.
Well, how does it end up with the insurance company being involved? In other words,
yeah, I understand your question. I think
it's one thing to file a claim against somebody's insurance. It's another thing to sue an individual, right?
Yeah, exactly. And they're suing. Something happens, and and the hunters sue me individually as the property owner, which they would because I'm perceived to have money, even though I don't. I'm perceived to be a rich, wealthy landowner. They're going to sue me, but if I meet those common law requirements and I have adequate insurance, the most they are able to sue me for is a dollar amount that is capped at the level of that insurance that I put on the screen and showed you. So they're going to sue me, but the most they can sue me for is that $500,000 or $1 million. My insurance company, if I've got that coverage, they're the ones that would ultimately be forced to make that payment if the counterparty was successful. So that's why they're going to be the ones that have the vested interest in providing the legal defense and would have much better legal talent than I could tap into. Yeah, they're not that. Does that make sense?
Yeah, I think what I'm asking though is, again, individual calls me and says, "Oh, you were negligent. I'm suing you," and then my response would be, "Well, I'm going to go see a lawyer first, but."
Yes.
I guess, I don't know. Do you go see the lawyer first or do you contact your insurance company?
I would contact, I'm going to contact my insurance because I've got liability protection through them. I'm going to contact them because really they're going to say, "Hey, did you do anything negligent or not?" You can't do grossly negligent things in terms of shooting at people or trying to intentionally harm them. But as long as you didn't do those, and you have the insurance, they're gonna provide the legal defense. You won't have to do anything.
Okay.
To me, that's the real peace of mind value of that provision. Because, man, it costs a lot of money to defend yourself successfully through the legal system. A lot. And many times you don't recoup that even if you win. So get the reinsurance and then have peace of mind knowing that that's not going to be a problem.
Yeah, I preach to people all the time about the cost of insurance, how reasonable it is, and how important it is to be properly insured. And anyway.
Right, and that's another thing too, is sometimes the insurance company will ask for a copy of your lease, and they will work with you to maybe say add this to it or drop this out or revise it. But I know when I got my policy and I bought my umbrella to expand my liability coverage, and I bought the right amounts, they just had me send them a copy of my lease, and I didn't get any feedback from them, but I'm sure if there had been something in there that was wrong, they would have gotten back to me. So to me, that was another perk in getting kind of a cursory review of the lease agreement itself, and knowing that they didn't see anything that stood out as needing to be reworded.
Excellent presentation. Thank you very much.
Thank you very much. Hope y'all have a very fun weekend.
Hey, Jason, there's another question in the chat.
Oh, okay.
Are we required to purchase the signs verbiage you referenced that need to be posted on the property for various activities or a specific place?
You're not required to do anything, but given the cost of these things, and you can, Texas Wildlife Association, Texas Farm Bureau, there's a number of entities out there, Texas Southwestern Cattle Raisers, there are a number of organizations out there that allow their members or non-members to buy those signs. You can have the sign made up yourself, but have it with that that letter for letter language and post it. You're not required to do it, but what I'm saying is through this presentation is if you go that step and post that verbiage through signs for those activities that take place on your place, that is one of those satisfying criteria that affords you that tremendous level of protection created from the statutes, which basically says, as long as you posted that the risks were inherent and they were assuming those things, and you didn't grossly negligently try to harm them, they assumed that risk, you're only going to be liable for a certain dollar amount that would be covered through your insurance. It's just a level of protection that to me is worth the 10, 25 or $50 that I might have to pay to purchase some of the signs and post them at the entryway. So it's just good management practice.
Well, thank you, Jason. If y'all have not seen it, I have posted a survey link in the chat box. Being that we are state employees on things, one of the things that the state likes to see is a survey from our program. So if y'all could take a few minutes and fill that out for us, we would greatly appreciate it. Not sure if I mentioned it earlier at the beginning of the program, but this program has been recorded today, and I will be doing some edits on it next week and posting it to our Tarrant AgriLife YouTube page. Once that is completed and posted, I will be sending a link out to everyone, as well as resending out the slides from the presentations today. Are there any other questions at this time? If not, we will go ahead and we will conclude the presentation and the meeting today. We'd like to thank everybody that joined us and have a wonderful weekend. Jason, as always, thank you.
Thank you very much. Y'all have